Well, it would seem as though this morning I'm having a hard time with this, but I was just about to forget our second witness. I really apologize for that. We have another 10 minutes. Ms. Beauchemin, will you be speaking? Yes. Ms. Beauchemin, you have 10 minutes. Thank you. I will be splitting the testimony. Is that fine? Yeah, that's fine. No problem.
Ontario Regional Status of Women Representative for UCCO-SACC-CSN. I have been a correctional officer for 12 years, and I currently work at Kingston Penitentiary, a maximum security institution for men. I will be discussing CSC policy and legislation, both of which make the job of a female correctional officer more challenging than that of our male colleagues. In May 2012, Minister of Public Safety Vic Tays was made aware that federal inmates had access to pornography on television. He announced that he would be putting an end to this unacceptable practice. To date, this has not happened. The satellite and cable television to which inmates have access for only pennies a day still includes sexual explicit channels and movies. Inmates are also still permitted to keep sexually suggestive and explicit magazines and personal photographs that continue to subject female officers to unwanted attention, unwelcome comments, and intentional displays of sexual gratification. How is it that inmates are not allowed to have material in their possession that has gang or alcohol-related logos, because these are considered to be antisocial, but pornography is acceptable? Female officers do report incidents of inmates deliberately masturbating and exposing themselves. In one of these cases, a female officer was conducting a routine hourly range walk on a midnight shift at a medium security institution. She observed an inmate masturbating in his cell. During each subsequent walk, the inmate appeared to position himself in such a way to make sure that she saw him masturbating. Later that night, he handed her a note offering to put on a show for her and asked her not to tell anyone. The next time she passed his cell, he asked her for an answer and whether or not this would get him in trouble. The officer reported the incident to the correctional manager on duty, yet despite the situation, she was not redeployed to another post. She submitted an observation report at the end of her shift, but the incident was not reported to the incoming correctional manager on the day shift. When asked to have the inmate moved to segregation, management refused due to a lack of bed space in the unit. Eventually, the inmate is relocated to segregation and institutionally charged by the officer. When the police are approached with a request to press outside charges on the inmate, they inform her that there really isn't anything to charge him with. Subsequently, the officer books the next shift off and ultimately uses up to 200 hours of sick leave. After a lengthy battle with senior management at regional headquarters, the inmate is transferred to Kingston Penitentiary, where he is reassessed and found to be a sexual deviant. The officer has since returned to work, but has not yet returned to full duties as a result of this traumatic experience. CSC policy states that inmates must be respectful to officers. The CCRA, the Corrections and Conditional Release Act, also addresses this matter. Unfortunately, intentionally masturbating in front of an officer is not clearly defined, and this needs to change. Officers must be given a viable avenue in which corrective measures can be consistently applied. Although officers have the ability to charge an inmate in these circumstances through the internal inmate discipline system, the officer must be able to prove that the act was committed by the inmate with intent to insult, offend, disrespect, and harass the officer. In our region, a review of charges filed in 2011 within a 9-month period demonstrated that nine charges were submitted for inmates masturbating in front of an officer. These charges were all classified as minor, and in one case, although the inmate did admit their guilt, there did not seem to be any final resolution. Criminal charges could be an avenue for officers as well, but again, there remains the difficulty of proving guilt beyond a reasonable doubt, and further that the offence is punishable by summary conviction. What is being permitted in our federal jails and its impact on female officers is contrary to CSC's own mission statement, which purports to rehabilitate offenders into law-abiding citizens. The ongoing exposure to pornography and to these kinds of inmate behavior, which seem to be without any consequence, causes female correctional officers, sworn-in peace officers, risks to their emotional well-being, and results ultimately in a loss of dignity. Female correctional officers face different challenges than their male counterparts do. Many of these can be addressed by amending the criminal code, the CCRA, and other policies, providing clear direction within the Correctional Service of Canada. We are not the problem. Thank you for your interest in addressing this problem. Francine and I look forward to your questions.
Bonjour. Tout d'abord, j'aimerais vous remercier de me donner l'opportunité de...
Good day. Thank you for this opportunity to speak to you. My name is Francine Boudreau. I am currently working at the Federal Penitentiary. This is a medium security institution. I'm a correctional officer for CSC, and I have been for 26 years. For all these years, I've had to work in 5 male institutions at different security ratings, maximum, medium, and lower security. I'm also coordinator for the Quebec region for UCCO-SACC-CSN. This area was generally reserved strictly for men back in the day, but over the last few years, women have been able to take up a variety of positions. Women, when they first started in this field, had to make it legitimate for women to work within penitentiaries. They were able to reach a point where they've got job equity, and women can gain an appreciation from others in this field of corrections. Women have had to face the fact that the correctional field did not strictly revolve around physical strength. Despite all of the government-related efforts to reach some representation for women in this field, as a full-fledged member of the justice system, we have noticed that there has been an improvement in the status of women, but there is still the issue that is quite unusual and, in fact, quite rare in other areas. In other words, sexual harassment from the client base, in other words, the inmates. Women have had to prove over the last few decades that they had the physical and psychological capacity to work in these difficult areas, specifically designed for men, showing that they have the ability and the capacity to intervene with these offenders. Given the strength that women have, women were able to claim their rightful place in this area. But women still face sexual harassment from inmates, something that men don't have to deal with. It would be false to believe that women are experiencing the same thing as men in these areas. Women experience sexual harassment from inmates, and they may experience a number of different emotions. They may be stressed out, concerned. They feel often they have to justify their behavior, that they did not cause this kind of conduct because of being women themselves. Women will have to deal with value judgments. They have to call into question their own acts, their own words. There's a lack of confidence from colleagues and superior officers. Women often ask themselves a number of questions. How will colleagues and superior officers react? What did I do for this to happen? If women isolate themselves because of this type of harassment and self-questioning, this could undermine their careers by doubly penalizing women. Women call themselves into question. They feel guilty, but they have no control over the reaction of others. Being a woman should not be a difficulty in and of itself, but often women are questioned about their behavior. Women should not, however, have to become more like men. They should be able to work without feeling that they are vulnerable to this type of harassment. Employers have zero tolerance policy on harassment, specifically between colleagues. But when sexual harassment comes from inmates, the resources are more limited. In actual fact, this type of situation is rather unknown because the people experiencing this harassment do not often call others out when it first occurs. Women don't often turn to colleagues or superior officers. This makes the problem more complex, not allowing women to find alternative solutions. Oftentimes, these solutions are not well known, and it's difficult to raise awareness within the community and solve the problem. From a disciplinary standpoint, it's a lot easier to prove certain types of behavior when it is offensive. Sexual harassment, however, is subject to interpretation in gray zones. So recourse is limited, but the situation exists, and it is important for everyone to know that in 2013, women who are to assert their role in this area have to continue to fight for their rights in order to have their rightful place alongside men in this field. 10 minutes on the dot. Thank you. That was well timed. So thank you very much. That was very interesting. I should say it's the first time I've heard correctional officers, female correctional officers before a committee, and I found your testimony quite interesting. You as well, but you know. So now we will indeed be moving to our question and answer session. The way things work is that I will tell you when you have a minute left, just so as not to have to cut you off midstream. So if you hear 1 minute, you can keep speaking. Don't worry about it. So we'll start now on the government side. Ms. Choupé, 7 minutes.
I'd like to welcome our guests. I think this is our largest group we've had since we've been doing this study. So welcome and thank you for your testimonies. I have some questions for PSAC. So Ms. Benson, it may be for you, or if you want to refer it to anyone else, feel free. It's a couple of questions in regard to your report. It states that most of the complaints are resolved informally and confidential agreements are drafted between the parties. Can you give me some examples of like I noticed that a lot in this report? Like it seems like a lot of different things are being resolved informally. How would they resolve that informally? Like, can you give me a couple of examples of what the consequence is if it's resolved informally?
If I can address the response to that, thank you very much. Well, informally is a bit of a misnomer because it can be informal without the utilization of various redress mechanisms, or it can be an informal at the end of a process of using redress mechanisms. So, for example, one of the cases that I've been involved with, at the end of a protracted process of trying to resolve this, grievances being filed, investigations, so on and so forth, a settlement offer was proposed and subsequently agreed to. So it's informal in the sense that normally settlement agreements are considered as confidential, so they're not precedent-setting, they're not publicized, they provide no information to the larger body of workers that a sexual harassment file has been dealt with in X way. So in that sense, it's informal.
So, would the results be monetary? Like, are they settling with money, or are they settling? Like it says, 54% of the respondents said they were satisfied the way informal complaints were resolved. So, what about the other 46%? Like, what happens to them? So, 56 are satisfied with what? With the recourse that was given to the harasser, or was it a financial settlement, or and then the other 46% that aren't satisfied, what do they do? Like, what would the next step be for them?
Well, certainly when you look at the actual brief, what we're quoting is that the public service employee survey indicates that 54% of the respondents said they were satisfied with the way informal complaints were resolved. Right. So that's the survey in and of itself. We have a process, the alternate dispute resolution, as an example, and so they'll go into a form of mediation, so there are no grievances filed. There may not be an actual complaint filed, but they've gone to the ADR officer, and so there's been a resolution in that manner. And so when Mr. Kerr speaks to some of the resolutions, yes, there is some compensation with respect to monetary awards, but there is also some resolution with respect to individuals being moved to other workplaces, and that's certainly what we haven't seen enough of is individuals moved to other workplaces so that the employer provides a safe environment for its employees.
Thank you. In case number 1, this was about the habitual harasser. And it seemed like everybody knew this person was a harasser, so much so that nothing really ever got done. And when new women were hired, they would sort of fill them in on this harasser. So I guess I'm just wondering, because I don't understand, how it works. I have not been in that situation. But I'm assuming you represent both, because I'm assuming in this case it doesn't say that it's a boss. So I'm assuming that they're both on the same level, in which the union would represent both, I think. And so in this case, the management did not fire the harasser. And the woman is still forced to be in the same area as this harasser, and new women that come on board, have to get apprised of this before they get there. So, can anything be done? Or is it because, as the union is obviously representing both, so that must be difficult to do. How do you do that? That you represent both? You're representing this guy who's still harassing women, but you're also representing the women that are charging him with harassment. How does that work? It must be complicated.
Well, for PSAC, what we will do is we will give information to the individual who is accused of harassment. We'll tell that individual what their rights are, but in the truest sense of representation, no, we don't go into the investigation meetings with them, but we will go into meetings with the individual who has laid claim to harassment. At the end, if the individual is found guilty of harassment, then we will certainly look at the discipline, if you will, in terms of what the quantum of discipline is. It appropriate? Did the employer do the investigation properly, thoroughly? And then at that point in time, there may be some representation. But from our perspective, the individual who is accused of harassment, we let them know what their rights are. But this is an employer investigation, and so we just ensure that everyone is represented fairly. But we will go in with the individual who has laid the charges.
Okay, thank you.
I don't know if Mr. Kingston wishes to speak to case one, because it's agriculture, but if you could, Bob.
Okay. In addition to that, what we do now in a case like this, we would be going back and we would be addressing it under the Canada Labour Code. There's no time frames around that. This happened within the time that the legal requirements to address it under health and safety were in place. As we find cases like this, we're going back and we're redoing them. So far, we are very successful. What that provides is a requirement on the employer to keep people safe, everybody, and it's not complaint-driven, it's awareness-driven. So as soon as the employer is aware of the situation, they must follow certain requirements. It's much more easy to enforce, and they have to have preventive measure recommendations that can be implemented and that health and safety committees can monitor for effectiveness, that provide ongoing prevention. And they also get down to what's called root cause, where you find out what was wrong at the management or supervisory level that allowed the situation to unfold and persist. And as long as the situation still exists, which in this case it does, right, then it's open to be addressed. And so we will go after this.
Okay, thank you.
Merci. Thank you. Now to the official opposition. Ms. Ashton, you have 7 minutes. Thank you very much.
Today and for your very important testimony important testimony for the study that we're doing here, and obviously a very key issue for so many people working in the public service as well and the federal workplace. I came across some shocking statistics in the brief that you provided us with today. 31% of all women report having experienced harassment, according to the Public Service Employee Survey of 2011. 54% satisfied with the way informal complaints have been resolved, obviously an indication of a significant number that weren't satisfied. And 44% of respondents felt that they cannot initiate a formal recourse process without fear of reprisal. So some pretty big numbers which speak to the real challenges that and the duty that we have as a committee to come forward with some serious recommendations here. My first question, Ms. Benson, and sort of having heard these statistics, could you tell us, in your opinion, why sexual harassment complaints aren't filed more often, and do you believe this is a cultural or a systemic issue?
Ms. Chairman?
Thank you for the question. And I think when you're identifying statistics out of the Public Service Employees Survey, you have to also take into consideration where the statistics came from. and I mean in regards to geographics of the country. Coming from a D&D perspective, our numbers were considerably high in relation to the overall public service survey. But when we actually looked at the satisfaction levels, if you want to call it that, the satisfaction levels came from the NCR. Out in what I call the real world, out on our bases across the country, harassment and sexual harassment are not treated the same way as they are in Ottawa. So the same level of satisfaction is not there.
Mm-hmm. Do you have some of those numbers on hand, or could you provide them to the committee?
I could give them to the committee following this, yes.
Okay. Thank you very much. Now, all of the public service has been subjected to some severe job cuts. In fact, in some departments, they've been more severe than in others. And I'm wondering if, whether it's Ms. Benson or somebody else, could say that, during this period, a period where the public service is facing such job cuts, and there is a tension, of course, in the air, do you believe that might prevent an employee from coming forward with an allegation in their experience of sexual harassment?
I certainly do agree that that's going to prevent them. It's difficult for our members in terms of filing complaints, whichever avenue, redress mechanism they use with respect to sexual harassment, let alone in the climate that they find themselves now. We have young women, our members, who are expecting their first child and afraid to tell the employer, their immediate manager, that they are indeed 3 months pregnant because of the cuts, and they feel that they would be cut because it's expendable. They're going to go on maternity leave. So when we do the retention process, they feel that they wouldn't fare as well. So it's not just sexual harassment right now that is an unsure climate for our membership. It's every member sort of ducking their head, thinking, "Not me, not me." Mm-hmm. Because of the cuts that are taking place. They're all very much affected.
Mm-hmm. Yeah, and that's very a powerful example of the deterrents that are out there. Mr. Kingston, given your involvement with policy, or your in-depth knowledge of policy, the Treasury Board, as you know, has come up with a new policy on sexual harassment. And I'm wondering, given this policy, would you say it's more effective, or how would you change the Treasury Board policy on sexual harassment to make it more accountable?
Well, first of all, I try and make it compliant with the law. The first thing is that the policy gives unilateral authority to a manager to determine how it will proceed, and the law doesn't. The law makes that absolutely clear. HRSDC has, in fact, issued directions to many employers when managers have taken that role upon themselves. But Treasury Board didn't have anybody at the table who understood the Canada Labour Code when they were drafting their policy, so that's where that went off the rails. Following the procedures that are coming under the Canada Labour Code and the section on violence, the advantages would be it's not complaint-driven, so as soon as they're aware. So that means anybody else, even if the victim is too intimidated, somebody else can raise the issue and have it dealt with. The investigation itself has required visible impartiality. The investigator is required to be seen as impartial by the parties. The scope and depth of the investigation, they get to root cause, and that's the only way you will ever get long-term prevention, is to identify what's going on in the system, what's going on at lower levels of management and supervision that is allowing these situations to evolve in the first place. Because usually if you just lop off the top where the problem is, it keeps happening. And anybody that's worked for a while in the public service can tell you about stories where managers 2-3 levels down, not necessarily through intent, but just because of the manager style or the system they have in place, they allow these problems to flourish. And the investigation under the code gets to the cause of that and is required to make recommendations about preventive measures. The investigations under other formats are not required to do that. They're required to make those preventive measure recommendations even when there's an informal resolution to the process.
1 minute.
Okay. So those are all positives. The other big difference is that when you go under policy. You have fences built around the investigation, not only in depth but in time. You're usually limited to a year back, and it's very difficult to build case history. Disciplinary letters disappear after 2 years off a file. 1 year is the cap that relates to the incidents you can investigate. No such parameters exist under the Canada Labour Code. You go where the investigation takes you, and in fact, you're required to look at history to figure out what's actually going on. So it's, I think, a whole new world, and I think there's all kinds of very positive possibilities. It's only been in place for a couple of years. It's going to be a learning curve, but the faster we get there, the better for all, I think.
Thank you.
Thank you. Now back to the government side. Ms. O'Neill-Gordon, you have 7 minutes.
Thank you, Madam Chair, and welcome to all our guests. It certainly is great to have you here. Now, over our study, we have been working diligently and to do this study, and have presented many hours and much on our study. And from all our presentations, there's one thing that we hear along the way, and that is seeing that workplaces strive for a place free of sexual harassment, and we feel this is very important to all. Now, I'm wondering, are there specific changes that you see that still need to be made to contribute to a harassment-free workplace for your members? Is there something missing that, and that could be for anybody, that we need to have put in there so that we can always have this harassment-free place?
I'm going to speak as a 35-year public service worker with D&D. We need our employer to respect legislation and the policies that they actually put in place. The harassment policy that we have in D&D, they call it harassment prevention. They promote zero tolerance, but at the same time, the policy, as Brother Kingston spoke to earlier, gives the employer the latitude to determine whether or not an allegation of harassment meets the definition. And it's the definition in the eye of the receiver of the complaint, not in the eye of the person that filed it. And quite often, complaints of harassment and sexual harassment are dismissed because the employer does not believe it meets the definition of what harassment or sexual harassment is.
Okay.
So we are looking forward, actually, to the violence prevention policy coming forward.
Someone has spoke about how quite often people fail to report it because they're afraid of their job. And I wonder if you have any numbers or specific incidents where over the time that will show this pattern, and if no change holds, like, if there's any, you have any example of people really worried, and how many numbers you have of these people who are worried of losing their job? What would the numbers be?
Ms. Elk? Thank you.
The numbers over the time.
Well, we don't exactly have numbers because we would never really know who was not willing to come forward, because obviously they haven't come forward. But I can give you examples, too many. My colleague and I can give you probably too many examples where the fear of coming forward and reporting wrongdoing, they have reached out to the union because they feel somehow we're neutral, we're safe. I had a case right here in the National Capital Region within the RCMP, a sergeant, a young woman, young mom, who was basically raped. She went to the Ottawa Carleton Police. She couldn't go through with the allegations and the charges, ended up not reporting it. Sad, extremely sad. She was fearful. She was a young mom. She was 24 at the time. What am I going to do? Who's going to believe me against a police officer? No one. But no, I don't have numbers for you, but we have examples.
Yes, if I may. We have some specific examples and numbers in terms of a specific scenario. So, for example, the case of Donald Ray, and just for your benefit, it's a matter of public record. The case has been much publicized. The disciplinary report was publicized on the internet and by the media. And in that case, the adjudication board, or the code of conduct investigation of Donald Ray, substantiated a whole series of allegations relating to his abuse of authority and sexual harassment of a number of public servants. And I don't want to go into, I could go into as graphic a detail as my colleague from UCCO-SACC, but but it may be pointless. But in our follow-up to this, we determined that the RCMP focused on the code of conduct and dealing with the recalcitrant member, but doesn't have a process to deal with the corollary issue, which is the sexual harassment and the suffering of those individuals. So as a union and our local follow-up to talk to these people to find out, well, what exactly has the employer done for you on this matter, because it was kept very secret. The majority of them are afraid of even speaking to the union about their issues because they fear job loss, they fear career damage, they fear retaliation, they fear a whole host of things. So I'm talking about a group of 7 individuals who are public servants who are affected in that particular case. In the case of case 2, I think it's referred to in our brief, that I personally represented in British Columbia, this individual over a period of time has also suffered retaliation in a variety of forms while pursuing her case. So the problem is that aside from what you hear in the media and what you read about, word gets around within organizations. People will talk to their close friends, and it's relatively secret, but the message gets out when you try to complain about harassment, and particularly when you try to complain about sexual harassment. You're in extreme jeopardy because the system, the old boys network, not just in RCMP and DND and other quasi-military organizations, but even in other federal government departments, the network and the understanding of dealing with sexual harassment is not there. And so women are fearful about complaining.
Okay, an added aggravation to this, the recent downsizing, the way that's having an effect is, in theory, the way it was supposed to take place is departments were supposed to identify work to be cut, not individuals. But what's happened instead in many of the headquarters here is that they just started identifying people, and they'll sort out what work they're going to get rid of after. And this has put a huge chilling effect on our members. And I know many of the headquarters offices in this town where people have been afraid to come forward with cases like this because of that. Because it is well known at the headquarters level that it's not the work that's being cut, it's the people that are being cut. And they are scared to death to come forward. So if that had been handled better, and if departments had been really forced, as the WFA requirements indicate, to identify work instead of the individuals, it wouldn't have had that chilling effect. But it's very sad to see. We're trying to figure out how to raise those issues on a sort of a more global and less personal level to try and protect some of these people. But and we have several complaints in about the abuse of that process.
Merci, Monsieur Kingston.
Thank you, Mr. Kingston. Ms. Groh, you have 7 minutes.
Madam Chair, and welcome back to everyone, and great to have all of these witnesses, but there's not enough time. So I'm going to suggest, because I have a variety of questions for representatives of the Solgen's office, if we could have corrections, the corrections representatives come back at a subsequent meeting. Okay, so I put that forward as a suggestion.
Madame Scrooge, j'ai arrêté.
Ms. Groh, I've stopped your time. There are some people in the committee who actually wanted us to ask the witnesses. In fact, we were waiting to speak to you, but because you had your time for questioning here, we wanted to suggest to the people that are here today that they stay an extra 15 minutes, given that we don't have another panel afterwards. So if everyone is in agreement and is available, I see that everyone's unanimous on this in terms of the members of our committee. So if you agree, we could keep you until 12:15.
Je pense que ça convient.
It seems suitable.
Canada issues that have been raised deserve more time than we're going to be able to give them with the extra 15 minutes. So I put that forward for consideration of our subcommittee at a further discussion.
OK.
All right?
15 minutes, puis on en discute.
Yes, we'll take those 15 minutes and we can discuss that matter further in the committee. That's all right? Yep.
Mr. Kurz, Ms. Hawk, thank you very much for being here. As you know, we initially started the study in response to some of the issues being raised by a variety of RCMP officers. And certainly the issue of Donald Ray is one of them that I have mentioned in the House and many of us have talked about. I guess I'm going to echo my frustration as well as, you know, no matter what policies we bring in, there are people who are going to feel intimidated, no matter how great our unions can be. And so there's a culture that has to change and a mindset that has to change. But in particular to cases like the Donald Ray, where the punishment is being transferred to another division or another department, another area, and he can just continue on. What do we need to do? What kind of policies do we need to have in place? Or is it should not be an automatic dismissal if the person's clearly been found in contravention of the kind of code of conduct is expected? Why in Mr. Roy's case was it not just a dismissal? If you could comment on, to the degree that you can comment. It's all been very public, as you said.
Well, there are a lot of problems that have been identified in dealing with the issue of sexual harassment in the federal workplace, and part of the problem is a lack of accurate statistical information. And in a PSAC brief, for example, a suggestion is made that when we do our next public service employee survey, that we clearly delineate a question concerning sexual harassment. When Ms. Trupp raised a question earlier about informal, I mentioned that one of the problems is that essentially the so-called solutions to these issues are being kept hidden. Too often, government departments, whether it be the RCMP, whatever, the resolution is buried in legalese where the complainant is essentially obliged to agree to a confidentiality agreement in order to obtain some form of redress to address their complaint. The consequence of this, of course, is that there's no statistical information for government departments at the end of the year to say we've had X number of sexual harassment files. And the other problem is that this methodology of dealing with cases doesn't provide any assurance to coworkers who may have similar problems as to how their department or their government handles sexual harassment in the workplace. So there's no way, for example, to advertise successes in dealing with sexual harassment. A lot of the other problems in dealing with this, in Donald Ray's case, for example, I sit on the RCMP working group that's going to deal with response to the changes as a consequence of C-42. And I pointed out to the RCMP regular member chair of that committee the other day two particular areas which I thought we needed to deal with. One was that not just at the RCMP but throughout the federal government, recognition needs to be given to applying the reasonable woman standard of assessing evidence when dealing with sexual harassment and gender discrimination files, rather than always looking at it through the optics of a man's eyes. And the other point that I raised to them in particular with the RCMP is that you can't always focus on how we're going to change the way we deal with regular members in the RCMP. You have to have a corollary process that addresses the victims, the victimization. And so they've taken cognizance of both of these two things. At the end of the day, people like Donald Ray should be fired. And if they were to be fired, and if that was a clear message that was pronounced in the media and within the departments, I think it would embolden, provide courage and support to females who are being harassed to come forward with these issues. But until such time as the government and its various arms are prepared to take that step and deal with this issue in a concrete fashion, change will be very, very slow.
Is C-42 going to really do much in its current form?
In my view, no.
Okay. Can you give the committee a list of some recommendations that you think need to be done over and above C-42, but the recommendations that our committee can make, and specifically to the RCMP and the kind of people working in the Sol Gen's office and so on?
Well, you have the RCMP and then the other departments that we service. let's look at Treasury Board policy, for example. Yes, there's a new harassment policy, but in my view, it's a dramatically weakened policy. And I'll give you a classic example. The old policy granted a complainant the right to review a final report before it became final, provide additional witnesses where necessary, documentation, clarification. The new Treasury Board policy has eliminated that. And so while Treasury Board says to all the departments, we have a minimal policy and you're free to expand, it's a crucial element which, in my view, should be obligatory for all departments when they deal with harassment cases, be they sexual or otherwise. 1 minute.
If you could supply the committee with some suggestions and ideas based on your role and your experience, we would very much appreciate that if it's possible.
I'd be pleased to do so.
Thank you. I
Go
just
ahead.
very much want to get over to our Correctional Canada witnesses and just say, wow, the fact that you're breaking barriers constantly for others by entering into working for Corrections Canada. It's the last place in the world I would ever want to work. So I applaud you on behalf of many women by saying we're equal and we can do the job every bit as good. No questions asked. And I do hope that we're able to bring you back so that we can hear more about the kind of challenges that you're outlining that on that one particular case, but I suspect there are many, so that we can be specific to some areas that are different than others when it comes to some recommendations that I hope will come out of this report. So I hope we'll have an opportunity to have you back again.
Merci, Madame Squirrel.
Thank you, Madam Squirrel. Now we're on to the 5-minute round. Ms. Ambler, you have the floor for 5 minutes.
It's okay. It's Madame James. Okay. Désolé.
Ms. James, sorry, there was a little mistake on our list. So, Ms. James, you have the floor, 5 minutes.
And thank you to all of our guests for being here. I'm actually going to direct my question to Ms. Chamberlain because you I believe it was you that had made some comments with regards to a question asked by my colleague, Ms. O'Neill Gordon, and it had to do with the current policy that's in place and the zero tolerance that the policy states. And I believe that you had said that the problem with that current policy is that it gives the employer the latitude to determine whether it meets the definition of the current sexual harassment or harassment definition. Now, I usually ask a question related to this, so I'm actually glad you brought that up because my questioning in the past has been referred to as the $1 million question. Being a politician, having run in multiple elections, you can imagine that many of us have, suffered comments or harassment in our ways to get here to Ottawa. So the way I look at it is some cases, what may offend one person may not necessarily offend another. And from discussions that we've had with other witnesses, the definition of harassment ties into the fact that the person who is the harasser should know or ought to have known that it may offend the other person. So I guess the $1 million question is, how would an employer know in that particular case that the harasser should have known or ought to have known when each of us are individuals and certain things roll off my back and other things really piss me off? So I guess that's $1 million question with that statement that you made. How is the employer supposed to know? There has to be a judgment call at the end of the day.
Good question, and I agree with you. I always say harassment is in the eye of the person filing the complaint. What is offensive to me should be investigated, and if it's determined at the end of the process that it's not harassment in the eyes of the law or the legislation, then provide that rationale back why it isn't. I recently was involved in three situations at this very same work location under the very same employer. One was a complaint under the employer's policy. 2 were grievances. All 3 were dismissed. In one case, there were 69 allegations against a co-worker. And the same employer representative dismissed all 3 sets of allegations saying that they did not meet the definition. When we addressed the concern up to the higher command, the response we got was, you don't have to like the answer, but at least you got one. If D&D is going to promote zero tolerance, then the persons filing the complaint have the right to be given due consideration. In one of the incidents that I identified, a third party actually recommended to the base commander that an impartial investigation be done. The base commander declined the opportunity to do an investigation, although it was recommended.
Okay. Thank you. You've mentioned 3 particular examples. Did any of those examples go further? Did that person file a complaint with the Human Rights or any other tribunal or any other, like, what happened to these particular cases? Did they go higher or did it not go higher? And I just wonder what the outcome of those particular 3 examples you just stated.
2 of the 3 are now at the final level of the grievance process, and depending on the outcome at the final level, we'll make a determination whether they can go to the PSAC for adjudication. The 3rd one I personally represented could have, the member could have filed a discrimination with the Human Rights, and I'm still working with him and encouraging him to follow up on that.
Okay, thank you very much. I don't know if I still have my answer to my million-dollar question, because it is discretionary, I guess, at best in human nature. So each person can think different things, and as I said myself, certain things roll off my back. But I'll continue to ask that question to every witness that comes in. Thank you. When we talk about statistics of employees that have experienced harassment but may not have reported it because they've been afraid, I think someone mentioned that we actually have no statistics on that. Like, do we have percentages of the number of employees that might fall into that category? Do we have any estimates? Because someone made
the data that is available is data collected under the Public Service Employee Survey. And unfortunately, the question that is asked in the survey is just an overall question on harassment. So it covers sexual harassment, but it can cover harassment on the basis of ethnic origin or religion or disability and so on. So we don't have any specific information. So it would be, that's why we're recommending that the survey be...
Do we know if the estimates or statistics, even though we may not have solid just on sexual harassment, do we know if over time they've increased or decreased? Or stayed the same?
Madame. I'll have to cut you off, Ms. James.
My understanding is that there's been a slight increase since the last Public Service Employee Survey. We're now at 31% women reporting harassment. If I remember correctly, it was 29% in the 2009 survey. So there is a slight increase, and we are concerned that that increase might be the effect of the cuts and the insecurity in the workplace. When women feel...
I'm sorry, Ms. Cote, I'm going to have to cut you off. Ms. James has completed her time. Thank you. So now we're back to Ms. Ashton. 5 minutes.
And I definitely support Madame Scro's proposal to have the corrections union come back to us, because we also feel that there are a number of issues there that you raised that are a bit separate than what we're looking at more broadly here today. So I certainly hope that is looked into. Back to PSAC, just quickly, Mr. Kingston, were you or was PSAC ever consulted in forming or shaping the new Treasury Board policy?
Harassment policy?
Yes.
We had consultation. What Treasury Board would deem to be consultation, not necessarily our interpretation of consultation. We have worked diligently to try and have some of our changes put within it. What we were successful at is actually keeping an harassment policy, and so I think that's an important issue to raise in front of the committee, is that at one point in time, of course, they wanted to take the harassment policy, put it into the workforce policy. They have a policy suites review taking place right now, which is undermining a lot of the policies that are in place. And I don't know if Mr. Kingston would like to speak more to it.
When the bargaining agents that were in consultation with Treasury Board brought to Treasury Board's attention that the policy did need to be compliant with the new violence regulation, that's where it started to fall apart. And the bargaining agent sides informed Treasury Board that they could not formally agree to or buy into the new policy as long as it wasn't consistent or compliant with legislation. So that became a major problem. And Treasury Board never put anybody at the table who understood that legislation, so it was a problem, and still is.
I'm wondering, because you brought up a very, the PSAC is bringing up a very key point around a policy that certainly has been presented as being the be-all and end-all to deal with harassment. So if you could provide in writing the pieces, and some you shared earlier that you feel are outstanding or ought to be improved upon to our committee, we'd certainly be keen to have that.
Can I just make one point now, because it's also an answer to the million-dollar question that was posed from across the aisle. The issue of a person like the perpetrator should have known and trying to get inside their head, when it's dealt with as a health and safety issue, that problem, like many of the other problems, disappears. The wording in the health and safety legislation, it doesn't talk about that the perpetrator should have reasonably known. It just says that can reasonably be expected to cause harm. And it doesn't say that's assigned to any individual.
Mm-hmm. Yeah, well, personally, for me, I mean, as a young woman in this work, there's a lot of sexual harassment in our universe, and I think the important point about the eye of the person living through it is the most essential in dealing with sexual harassment. Ms. Chamberlain and Ms. Kurz and or Mr. Kurz, pardon me, and Ms. Hannock, you brought up some very important cases, both in the RCMP and reference to civilians working in defense. And I'm wondering if there's other cases that you have. Obviously, the ones you brought forward were shocking enough, but other cases that you feel are both examples of the harassment that exists, but obviously the lack of action that's been taken to provide redress.
1 minute.
Well, speaking for USG, as you know, all the components have a mandate to represent departments from X departments, and my focus and the bulk of my work, it happens to be with the RCMP, although I represent employees at a number of other departments. I would have to say that in preparation for this appearance, I focused on the very difficult issue of one individual trying to resolve her sexual harassment complaint. That's the case summary of Ms. R. And I have copies of a more elaborate summary, if you wish, I could leave with you. And of course, the case of Donald Ray. From my perspective, what would be important for this committee to take away from the RCMP situation is the crucial realization that while all the publicity has been on the plight of female regular members of the RCMP, just the nature of the beast of the members that we represent, and the fact that we operate under a different act as compared to the RCMP Act, our approach has not been public and cannot have been public. But I would hazard a guess and say that on a pro rata basis, there are probably as many sexual harassment concerns of public servants as the RCMP as there are regular members of the RCMP.
Je dois vous arrêter ici. Ouais, on a dépassé notre temps un petit peu.
Sorry, your time is up. Ms. Ambler, it's your turn. 5 minutes.
Thank you to our witnesses for being here today. Very interesting testimony you've provided, and so I thank you for that. I'd like to address the example of the woman who is 3 months pregnant and worried about her job. Was that you, Ms. Mentis? Sorry, I knew it was in this area. Thank you. And I believe it was as a result of Ms. Ashton's question about looming job cuts. So I guess. The reason it struck me is probably because, like many of us in the room, we've all been working and pregnant at the same time, and worrying if our employer will look at us differently and consider us a bit more expendable because we're going to be taking maternity leave and maybe not worthy of keeping on. But I guess what I'm trying to do is understand better how that relates to sexual harassment in particular. And so, or is it that you consider that choice and not to continue the employment of someone who's 3 months pregnant, do you consider that sexual harassment, or do you believe that I'm trying to link how job cuts cause sexual harassment?
It is not that job cuts cause sexual harassment. What I was trying to convey was the question was sexual harassment and why don't people come forward? And because women are afraid to come forward. They're afraid to come forward and say that they have been sexually harassed because it will impede perhaps their career, what's going on within their workplaces, whether they'll be actually believed that it's taken place. And so when we're talking about the job cuts and the real fear out there, I think that it's probably quadrupled that if there was sexual harassment, women would not be coming forward. Because what I said was, my goodness, I was at a meeting and there was a young woman who was 3 months pregnant who was saying, I'm afraid to say that I'm pregnant for fear of losing my job, let alone the woman sitting beside her who may in fact be sexually harassed, and she's not going to put up her hand and say, well, I'm being sexually harassed, could I still please have my job? So I think that you have to look at what the climate is within our workplaces right now, where the job cuts are taking place, where the process that's in place is very unfair, which I have spoken to Mr. Clement about. Because we don't have seniority within our workplaces, individuals are forced to compete against their colleagues because, as Mr. Kingston said, it's not the work that's leaving, it's people that are leaving, and the work is still there. So what my reference was is that in today's climate, with all of the looming job cuts, if there is in fact, and there is, sexual harassment in the workplaces, those women would not stand up and say and file a complaint that they've been sexually harassed.
Okay, and that's certainly what we think in some cases what we think might happen. Other than never cutting jobs or firing anyone for any reason whatsoever, what is the solution to that problem? Other than complete job security, what's the solution to that?
The solution to sexual harassment in the workplace is that the employer has an obligation to have a safe working environment.
No, what's the solution to the problem of people not wanting to report because they feel like their job might be in jeopardy? Other than giving them 100% complete security that they'll never lose their job for any reason.
1 minute. That's a good question.
I guess maybe it's too much of a philosophical question.
Okay, so the solution to that, a transparent, like we all know there was a downsizing process. As I said, it was supposed to be based on work identified and people then associated with that work. It didn't happen. What they went in is they just started targeting people and then sorted out after. So if you changed it to what it was supposed to be, that would be transparent. Also, the website that would allow people to change. That was never managed, never set up properly. When we did that in the 90s, we actually did it physically. We managed alternation process, so it was a lot more transparent and it was much more well received. And this specter that you'd be picked on, you're in trouble.
When you talked about jobs versus the work itself, I found myself... okay.
I'm sorry, your time's up.
Merci.
Thank you. So we still have time enough for a round of questions. Ms. Ashton, 5 minutes.
Thank you very much. Back to the cases. I want to make sure that Ms. Chamberlain and Ms. Hannock have an opportunity as well to share whether it's cases or some of the trends that you see in your work.
In preparation for coming here today, I actually canvassed my staff because I'm not directly involved in the representation of the membership. And quite frankly, I have not personally witnessed or experienced sexual harassment. Even though D&D may not be the greatest workplace, I enjoyed my work with D&D. So I asked for examples if we had any ongoing cases. And I was surprised to find out we actually have 4. One was an actual allegation of a male member against a male member, but I don't know what's going to happen with that one. Another case that was brought to my attention was one of our female members filed a charge of sexual harassment in the workplace. She's in a non-traditional female job, working with a group of males. And the outcome of her grievance was that the complaint was not founded, and she is now actually facing allegations of filing a frivolous charge and is under investigation herself. Another case, the employer actually upheld a grievance of an allegation that a male co-worker exposed himself to another female member, and the respondent received a 5-day suspension. The reason the grievance is at the final level with us is that the complainant was not happy with the outcome of the 5-day suspension. She felt that the penalty should be more. And the fourth example I have that I was given was that we actually have a person who's been accused of touching female co-workers, and that the employer is possibly looking at workforce adjusting this person and giving them a buyout to leave. And that's how D&D addresses harassment in the workplace.
And just quickly, because I know our time is short, I will speak on behalf of the memberships within the RCMP. Unlike Mary, I am on the ground. I have been with the RCMP for a considerable number of decades. And my colleague, Brother Kurz, he very eloquently said that, yes, it knows no bounds. So whether you're a regular member facing sexual harassment, a civilian member, or a public service employee, because within the RCMP we have the 3 levels or the 3 categories of employees, it knows no bounds. I can give you example upon example if we had the time, but I think that the key in the RCMP is that the police officers are our protectors. They are our members in society that we turn to each and every day to say, please keep us safe. The last thing we believe as an employee is that they will be the offender. That is the last thing we believe. They're also in positions of authority. Those are our managers for the most part. They are the police officer. So they are a police officer over here and our managers over here. So we have power of authority, abuse of authority. We have the protectors of society. Well, we'll just not worry about whether we have to live up to those expectations. They, as the RCMP, should have a very high tolerance for differences. And it doesn't matter if it's a difference in your sexual beliefs or your ethnic background. They should have a high tolerance. They don't appear to have that. So for me, as a worker within that workplace, representing employees and members of the PSAC, it becomes very difficult because they police themselves in these situations.
Very much for that. And just going back to C42, what consultation took place with your colleagues, and perhaps what sense do people working as civilians on the ground have that C42 will make any difference?
As an offshoot of a normal labor management consultation process, USG was offered the opportunity to take part in a variety of working groups to assess or deal with differing elements of C42. And as I mentioned earlier, in my case, I sit on the working group that's dealing with the issue of harassment. Quite frankly, the assessment of the membership that I have contact with, and I represent the RCMP in Western and Northern Canada versus my colleague who does Ontario East, I think it's safe to say that the assessment from the public servants is that changes to C42 won't make a hill of beans of difference in handling of harassment, sexual harassment, or many other issues at the RCMP.
Je vais devoir vous arrêter ici.
I have to cut you off there. So actually, we don't have enough time to start another round. So this is what concludes our meeting. I thank you very much for having come to meet with us. It was very interesting. Now we will be moving in camera to deal with committee business. So I will be suspending for a few moments so we may move in camera.